All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. I will now ask Mr. Doug Shima to please call the 10:30 docket.
Thank you.
First case on the 10:30 a.m. docket for Wednesday, May 20th, 2026. Appeal number 127119. Sharon Rogers and Robert Rogers individually and heirs of law of Aaron Rogers and as the co-administrators of the estate of Aaron Rogers versus Matthew Moll, MD, appeal from Butler County.
Jim Howell of Prochaska, here on behalf of Sharon Rogers and Robert Rogers, as well as the estate of Aaron Rogers, and we're present and ready to proceed.
Thank you.
May it please the court. Good morning, Brian Burge, Sanders, Warren, and Russell, on behalf of defendant appellee, Matthew Moll, MD, present and ready to proceed.
Thank you, Mr. Birch.
Second case is appeal number 128056, State of Kansas versus Charles C. Hunter, appeal from Pawnee County.
May it please the court. The state appears by Deputy Solicitor General Chris Ailslager, present and ready for argument. And so I don't forget, Mr. Chief Justice, I would request 3 minutes of rebuttal time.
Thank you.
May it please the court, Joseph Dash appearing on behalf of Charlie Hunter, present and ready for argument.
Thank you, Mr. Dash.
Your Honor, that concludes the docket for the week of May 18th through 20th.
Thank you, Mr. Shima. I will now call the case of Sharon Rogers et al. Versus Matthew Moll, MD, case number 127119. And counsel, you may approach and begin your arguments when you're settled and ready.
Thank you, Your Honor. Good morning, Justices, Counsel.
For clarification, you did reserve 3 minutes for rebuttal.
With the court's permission, I'd like to reserve 2 minutes of rebuttal.
2 minutes. Okay, thank you. Yes.
Thank you.
Go ahead, you may proceed.
Again, Jim Howell appearing on behalf of the appellant Sharon and Robert Rogers. Thank you, of course, for allowing me to appear before you to share my thoughts on this case this morning. It's always a pleasure. It's been a while, quite frankly, since I've been before the Supreme Court. Quite some time, actually, but it's always a pleasure. A little intimidating, but that's what happens to us lawyers. Anyway, Justices, this case not just about what happened to the Rogers family more than 10 years ago when they lost their daughter, Erin. This case is not just about a trial that occurred more than 2 years ago. It's a little deeper than that. It's more, I consider it to be fundamental than that. And why? Because the important thing here is that we ask ordinary citizens from all walks of life to involuntarily appear at a foreign place and sit quietly through a foreign process with no idea about what we're going to be asking them to do, and quite frankly, how to go about that. These are citizens with no legal training. These are citizens with no experience in the legal system, or trials for that matter, with the exception of maybe fictionally what they've seen on TV or at a movie theater, which is not particularly helpful. But fundamentally, this case is about how we guide these inexperienced citizens in our system of justice to make important decisions involving life, death. That's what it's all about. It's about clarity in the guidance and directions that we give those jurors and the pathways and the roadways that we construct for them to follow in our system. We as attorneys, of course, we know it so well. We call these instructions in the legal vernacular, but to ordinary citizens, these are more like guidance and directions on how you do things. So when we as lawyers and judges do not adequately provide that clarity, that guidance, that direction in those pathways and roadmaps, justice is questioned, and it is here. We respectfully submit that what happened in the courtroom in Butler County, Kansas, more than 2 years ago is a prime example of how the failure to create a pathway or roadmap for the jurors can lead to an injustice which we believe occurred. At the risk of repeating what appears in the briefs, I know you all have read them and you don't like for folks to repeat all that, but I would like to briefly discuss the fundamental importance of this as it is applies in this case, those requirements of clarity, those requirements of of guidance. Well,
Counsel, can I just drill in without hopefully not interrupting or sidetracking you too much? But I think I understand the nature of your complaint. It originates in what maybe we call contention instructions that identify the respective positions of the parties, and that essentially your proposed language setting forth your theory on causation was cut out. Is that a fair summary of your?
it's deeper than that, Your Honor. It goes to the entire guidance, the entire pathway that we as plaintiffs created. It started with the contention instruction, which we believe we have a right. It's our claims, if you will, to set forth what our claims are, what we're claiming specifically. And it needs to be clear enough and have enough of an explanation in it that the jury can understand what we're claiming. But it's also in the instruction that the next step, which you have to have, which is the law that we provide. The law has to be clear as well. And we take issue with that instruction as well, which is why we modified it with PIC to include the phrase fault, to keep the consistency there. But then we go to the next step.
Before you start getting into the others,
Sure.
if we're looking at contention instructions, they strike me as a little bit different in the world of jury instructions in that they're not true legal instructions, right? They're almost factual summaries. And I'm wondering if our typical standard for reviewing those instructions, whether they're legally and factually appropriate, if that test even makes sense to this type of an instruction.
I would suggest that to a certain extent it does, because you don't want to have even a claim that's being set forth in a contention instruction that is not supported by the law. It'd be totally contrary to the law. So that would be misleading. But in another sense, it really is not as applicable as what Your Honor says. It's a little different than that, because it really is an explanation to the jury about what the plaintiff is claiming went wrong and the consequences of that. Because if the jury doesn't know that from the very beginning, it's pretty hard for them to get a start and then look at the law and apply the law to that. Yeah, they've heard all the evidence. I understand that. But to have a set of paper, some pieces of paper that provide them with a guidance, some guidance, a pathway, if you will, a roadmap, a recipe that they can sit down and follow, that says, okay, well, here's what they're claiming. Here's what's going on. Here's what they say that they think somebody did wrong. And if they were negligent and they caused it, blah, blah, blah. All of that goes in that contention instruction, which I believe why it's called the contention instruction. And it starts out with the word claim. That is important for them starting place. And then they're instructed on the law. They've got to then take that law, go back to that instruction and say, how does this fit together? And then ultimately they take those two instructions, the contention instruction and a standard of care or duty instruction, and they go, what's the question I'm supposed to answer? What's the issue? What is it about? In this case, of course, it was about fault. And then they go to the verdict form. And then the verdict form needs to be specific enough and give them enough guidance to say, okay, looking at the contention instruction, looking at the standard of care instruction, this is what we've got to decide. So they're asking us to decide this question. So all of those need to be clear, and all of them need to create a pathway that they can follow. And when it doesn't, you've got a problem, because you don't know whether they really understood the claim, whether they really could understand the law and apply the law if it's not clear. And then what did they really come up with? Like the fine for example, we have a verdict form. It's not very clear as to what they did. It just opens the grounds for impermissibility for findings in favor of, if you will, particular party. So my argument and my position is, and I'm sure it's in the brief, and I'm sure I'm re-arguing things again, and I apologize for that, but it really is, we start with that mandate. We start with the mandate that's set forth in 6249A2. The court must give the instructions and explanations that are necessary to enable the jury to make the findings on each submitted issue. That is mandatory. It's crystal clear. You can read the cases, it's mandatory. The instructions must accomplish that to be legally and factually adequate, because you just have to have that. If you don't, then there's a disconnect and the jury doesn't have a pathway to follow to reach a proper decision. It's going to be subject to question, as I said. So how do we ensure, as lawyers and judges, that that mandate 249 is met? Well, we tell the jury, first of all, what's claimed, the legal theory and the facts, what our contentions are, what we're claiming, what we have to establish in order to prevail. That's step number one, the contention instruction you're on. That's what's being claimed. We claim that somebody did something wrong and what happened because of that. We start with that. Then we provide the jury with the law, that is what the plaintiff needs to prove to prevail on their claims, which is typically the elements of the cause of action. In this case, it would be medical malpractice, the three elements that were there. And then we define the disputed issues to be decided. And we ask the jury to decide those issues with particularity. That's the system we put together. So how do we communicate that to the jury? That's really important. How do we get that to the jury that that's what they need to know and that's the decision they need to be focused on? Well, we accomplish that with a contention instruction, a standard of care instruction, and a special verdict form. Those all have to be done. They all have to be accurate, factually and legally. But the key is that sometimes we miss the point on, those all must have a synthesis. They must all go together. There must be cohesiveness. They've got to create something that a person, like putting a bicycle together, needs instructions. They've got to be able to walk down that path. If we don't have that path and we don't have a verdict form that's accurate, tells them what they need to be looking at and to consider, there's a problem. There's a failure in the system. And that system failed in this particular case.
Why, drawing your attention to instruction 13,
Yes.
why isn't it enough that you've got the sentence there in the last paragraph that says defendant denies that he was negligent in the care and treatment of Erin Rogers, or that he was at fault in causing or contributing to her death? You've clearly got the causation thing referenced there. And I have to assume that you don't mind that sentence.
Well,
You must be saying that it's not enough in the context of the instructions taken as a whole. So I guess my question is, why doesn't that sentence cure your concern?
it's a very good question. Very good question, Your Honor. And there's 2 points to it. The first one is that it's fundamentally backwards. It's what the defendant is disputing. And if we look at the Reardon case, where you must explain the elements of the claim that's being made, it doesn't explain the elements of the claim we're being made. You're looking at what the defendant disputes and what his contention is. We're entitled to have our own contention, tell our own story, tell us what our claim is, regardless of what the defendant says. So I think it's improper to draw that inference. And then again, you're asking jurors who don't have any education whatsoever or training in this legal area to sit there and go, well, I think if this says that by the defendant, what it means is that they must be claiming, the plaintiff claiming this. And again, we're asking laypersons to make those decisions, which is very difficult. And therefore, I don't think it's appropriate. I think Reardon, and I think the necessity of allowing us to state our claim is really important. It's our claim, and we need to make sure that we believe it's understood.
Can you connect those dots for me? In other words, is there a simple way for you to articulate how, in your view, these specific instructions led to the defense verdict?
Well, a couple of different things. And it really is kind of identified with what went wrong. The contention instruction did not lay out, I mean, it said, we find fault, following fault, blah, 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 and it laid out negligence claims. Nowhere in the contention instruction is fault explained, and nowhere in any instruction is fault explained. Fault is important because fault is negligence plus causation. Even the standard of care instruction only spoke to negligence, didn't speak to fault. So when a jury looks at, apply that law, going back and looking at the contention instruction, the jury's going, okay, fault, where's fault? They can't find fault. It's not there.
But why does that, that's what I'm asking about, connecting the dots. How, in your view, does that generate the defense verdict?
Well, I don't know what the verdict truly was, but yes, it appears to be a defense verdict because they found for or in favor of.
I mean, it's clearly a defense verdict. That's why you appeal.
Setting that aside, Your Honor, I think the problem is that we have to have consistency. We have to explain to the jury how all of this works. So we say it's negligence. That's the duty. That's what you need to have. Negligence. So then you go to the contention instruction, you go, well, they're talking about fault. I don't see anything about negligence. Was in there, got stripped out. So the jury just had a total disconnect. And I respectfully suggested what the jury did was they just said, well, I think we're going to find in favor of the doctor because.
Right, and that's what I'm asking you to.
I don't think that they really
articulate.
truly.
What's the fill in the blank? Why, in your view,
Mhm.
did the jury find in favor of the defendant?
Well,
In other words, what was their confusion? Why did they screw it up?
I think it's because they didn't have a clear pathway to understand that if with our claims of fault, we had the negligence that was
So you
laid
think
out.
that because the
The-
instructions did not clearly delineate the elements of medical malpractice, the jury just sort of threw up its hand and was just like, well, we don't understand, so we're going to rule in favor of the defendant.
Correct.
That's
And I
what you
think they
think
just
happened?
considered everything they'd heard. And they heard a lot, and they heard a lot in closing argument, like.
And they heard a lot and they understood what the duty of care was, and
Mhm.
causation was even, it's at least mentioned, if not, I mean, instruction 12 describes the need to determine the cause of death, which is medical and scientific in nature, et cetera.
Again,
Let me put the question a different way. Had the jury been so confused, why wouldn't they have just thrown up their hands and said, well, we're just going to rule in favor of the plaintiff?
because I think they would have looked at the claims carefully if the instruction hadn't been gutted, and they're gonna see fault, and they're gonna look at the standard of care instruction, and they're gonna see that it's not just negligence, but negligence cause is fault. Take that fault definition, go back and look at the contingent instructions and say, yeah, he did those things, and it did cause death.
You think the jury thought that the doctor was negligent, but not at fault?
That's possible, but I don't know for sure what the jury thought. That's the problem with the verdict form. And that's why the verdict form in and of itself is, I believe, reversible error. Separate from all the rest. Well, I've taken up my time, so.
Can I briefly ask you really quickly
Of course.
on the causation, in addition to instruction 13, the damages instructions seem to also tie in causation, at least, that if there is fault or liability, a breach of the standard of care, it says that you're to compensate for loss caused by the defendant's action. And then in 15 says resulting from the occurrence in question.
Right.
Does
They don't get to that. They have to answer fault first.
Right.
Or who do you find in favor of? So we're taking the consequences rather than a legal standard, a legal definition. or legal question they need to answer. You're taking the consequences. If you answer the question this way, you have damages. And you're taking that language and you're asking a layperson to infer from that language that follows it. Well, I guess that if that says that, that means that we had to find this. So this must be the question. You're asking him to walk backwards. And I think that's unfair. I think our job is to make a clear pathway, and we didn't. And with all due respect to the Court of Appeals, I think that they looked at this and they struggled with that very issue with the jury instructions and just stopped short of saying they're not adequate for that very reason, because the pathway is just not there. And if we don't do that, then we've got a problem. We've got to look at these. We got to be fair. And the verdict form just compounds it. Thank you.
Thank you. Mr. Byrd.
May it please the court, Brian Burge for defendant appellee Matthew Moll, MD. I think that this appeal does not give due credit to the common experience, common wisdom, and common sense of a jury in a non-comparative fault case with a single defendant, where the contention instruction lays out 4 separate ways that the plaintiff contends the defendant is at fault. That term meaning, with no other defendant present in the case, the person who is responsible for the outcome. There is no other way for a jury hearing a case like this to understand what it means when you have a single defendant where there are no other allegations of comparative fault as to who could potentially be responsible and who has deviated from the standard of care. And of course, the standard here on review is, has the jury been misled by the instructions? Or as a whole, do they legally and factually set forth the claims appropriately? And Justice, as you mentioned with instruction number 12, when you look at these in context and you look at the way that the jury was instructed, instruction number 11 is the definition of the standard of care, which says a violation of that is negligence. So you know right there what the standard is. And then if you look at instruction number 12, it actually sets forth both liability and causation. Liability must be determined by what you have heard from the experts as to what constitutes the standard of care and to the alleged deviations by the defendant. I can tell you there were 2 full days of testimony by the plaintiff's primary medical experts in this case, Dr. Janiak and Dr. Terry. The jury heard more than enough evidence as to what the plaintiff's allegations were about the standard of care. And then the second part of instruction number 12 says, you are to define causation. You are to determine whether Aaron Rodgers died as a result of what these experts tell you. And again, each of the plaintiff's experts who got up there and testified about the alleged deviations from the standard of care certainly said those deviations caused this individual's death. That is liability and causation, and it's set forth very clearly in instruction number 12. And then logically, you follow instruction number 13.
Sorry, I didn't mean to interrupt your argument there. Instruction 12 is really a mode of proof instruction, saying that, you need expert witnesses to support these concepts. It is interesting to me that maybe it's because we so frequently focus on criminal instructions that there's just not one elements instruction in this case. But that maybe begs the question, is not terribly relevant here, but that doesn't exist in this case, right? They're sort of parsed out in the instructions as a whole, which.
And I think there's a reason for that. The court is probably familiar with Pick Civil and the fact that the only definition of fault in Pick Civil is contained in the chapter on comparative fault. There is no other portion of those pattern instructions where fault is defined. And I think there's a really important reason for that. because the very first sentence of 105 says, you must decide this case by comparing the fault of the parties. And in that circumstance, fault is defined as not just causing, but contributing. And so the jury needs to understand that when you have more than one party who may be at fault, it is not just, are they the majority at fault? It's, did they contribute, so that they can assign percentages.
Doesn't that suggest that using the word fault was an error in this case?
That's the way that Pick is written. I mean, whether, you know, the appellate court took a little bit of an issue with whether you say due to the fault or at fault, but that's where the appellate court or the Court of Appeals, you know, said, let's think about this from a common sense perspective. What does fault mean? It's who is responsible. And if you had,
Yeah, and I understand that. This is a unique kind of argument or situation. If it is in fact true that there is a error in Pick, how should we as a reviewing court in this case think about that?
well, I would respectfully submit that I do not think there is error.
I understand that, but
Okay.
I want you to assume with me for purposes of the question that we might think that it's error to introduce the notion of fault into a case that where it doesn't belong.
Well, fault is, of course, necessary. It is a necessary element of proof. And the question,
Well, is it? I mean,
I think,
at common law, that was not a term of art. It really comes in because of the notions of comparative fault, right? I mean, that's what you just described to us.
that is the only place that it is defined, is under the
And
chapter.
that
on
may be the
comparative
only
fault.
place where it's an appropriate concept at all.
I think, I'm sorry, I didn't mean to interrupt.
No, and I'm not trying to press you to agree with me per se. What I'm really interested in is, because I'm sympathetic to the idea that maybe Pick might contain errors, and I'm unclear what a reviewing court should do with that fact. In other words, there's some sense in which if it's in Pick, so the reviewing courts sort of just say, well, it's in Pick. Okay. We don't have a category necessarily for whether that's an error.
I do think that's the reason you see the instruction separately define negligence as being the deviation from the standard of care. And then if that's read in conjunction with instruction number 12, you need the deviation from the standard of care and you need causation, which, you know, we could say, instead of using the word fault, you could just say these deviations caused.
Well, right. That's
Yeah.
what we would say at common law. We would say, here's the elements of the claim.
Hmm.
You have to have a duty, a violation of the duty, causation, and damages.
I can't,
We all learned this in torts 101 or whatever,
Yeah.
right? Those were the elements of a common law claim.
I can't presume to obviously speak for the committee, but I would think that it seems such a common sense proposition that when you only have one defendant, and that's who the allegations are against, and you've got a situation like this, you know, where you're alleging that the patient died because of his conduct, there is no other way to think about fault than to assume that if he's negligent, if he deviated from the standard of care, it caused the death, because that's what all the evidence says. And so if you're thinking about a jury, thinking about a group of lay people considering all this, that is really the only outcome, is that he has to be responsible for it. And then, of course, that gets into, you know, the jury's ability to weigh the evidence and decide what they think. But I do want to touch on the verdict form, because I know that that was raised as an issue as well. And I think this goes back to the idea of why the committee does not include a definition of fault in a non-comparative fault case with a single defendant. If that verdict form would have been submitted the way that the plaintiff suggested, and the jury was asked to decide, do you find or do you believe Dr. Moll was at fault? Think about how they could have interpreted that question. They could have gone back to the jury room and said, he's a little bit at fault. He's 20 to 25% at fault. And then they have no means of setting that out. The question is he at fault, yes or no? And if he is, then you award damages.
Circling back to my question, isn't that exactly why using fault as a concept is error in the first place?
And maybe that's why they didn't. And I mean, I
In
can't,
other words, you kind of can't
Yeah.
have it both ways, right?
the contention instruction, let me look at the form for just a second here. Yeah, I mean, it clearly says in the form, the plaintiff claims he was injured due to the defendant's fault. And that's Pick. And of course, it's been drilled into all of our heads at the trial court level that you got to use Pick. And again, there is no definition of fault included in a non-comparative fault case. So this is what we're stuck with. But that might be a very important issue for the committee to consider. I do not think it's an issue that should justify overturning the jury's verdict in a case like this, where as a whole, I do think the jury understood absolutely what their obligation was. I think it was very clear what the allegations were and what was required to try to show whether Dr. Moll caused the death of this patient. This was a 2-week trial, a gut-wrenching trial, a trial that I will always remember, and that has, that doesn't even account for the grief of the family. These obviously things take a lot of time and effort. And I can tell you that the attorneys on both sides did everything possible to try to comply with Pick the way it is written. And one of the reasons that we objected to the plaintiff's proposals during the instruction conference is because they were not Pick. And because of the weight of this case, we wanted to make sure that we were following Pick as closely as we could. And one more thing about the verdict form, to the extent that that becomes an issue, again, we submitted a general verdict form, and 18102, the way that Pick instruction is written, it clearly says, we, the jury, either find for the plaintiff, that's one option, or the second option is we find for the defendant. And the way that 18102 is set out is those are two questions. We just put them on the same line and said, do you find for the plaintiff or do you find for the defendant? And we felt that that was proper, again, in a non-comparative fault case.
I want to ask you again about what might have happened in that jury room. And obviously none of us knows. We're trying to infer. You said a moment ago that you objected to putting fault on the verdict form because of the possibility the jury might deliver an improper verdict based on an understanding that they thought, well, he might have been 10% at fault. So we're going to say yes.
Yep.
And I want to ask you the opposite question. Couldn't this jury also have believed that there was negligence and causation, but that because of a colloquial understanding of the word fault, it really wasn't the doctor's fault? It's just bad luck, or it's God's fault, or it's, why isn't that also a possibility?
I don't think so, because of all the evidence presented in this case, those four contentions, that those four elements of negligence that were set forth in the contention instruction, there was overwhelming evidence presented on both sides fighting against those four contentions. And I think the jury considered all of that evidence, and in light of those four very specific contentions, and decided that they did not believe the plaintiff had met their burden of proof to show that Dr. Moll was negligent. And then in conjunction with instruction 12, and that Dr. Moll denied causing the patient's death, I think it was very clear to them what their finding was. I will tell you, I just tried a case last month here in Shawnee County with the exact same scenario, wrongful death case, medical malpractice, single defendant. And because of this appeal, I did it the other way. I agreed to allow a definition of fault to be placed in the standard of care instruction, and I allowed the verdict form. I did not object to the question being, is the defendant at fault, yes or no? And I can tell you, I spent a lot of time in closing explaining that to the jury, because that's what happens here. The instructions themselves are not clear on their face. I had to explain to the jury, fault is a very, very loaded word in this trial because it requires two things of you. It requires you to find that the doctor was negligent and that it caused or contributed to the death. And I don't think that we should have to do that. The instructions should be clear enough on their face that the jury understands that. And it should not be a situation where I'm in closing trying to tell them what this really means. And I think here, this was actually done better than it was in the case that I just tried last month. But for those reasons, I believe that the jury's verdict should be affirmed, and unless there are any other questions. Thank you.
Thank you. Any other? Thank you. You reserve 2 minutes.
Very briefly. What is so important about this case? Again, the pathway. Why is it so important? Because we don't know how the jury arrived at its verdict, and we can't go and ask the jury. I mean, we have specific rules that say you can't do that. 6441 says we can't go ask. We can't go find out from the jury and present evidence later in a motion for a new trial. We can't go ask them and put affidavits in front of the judge and say, hey, this is how they arrived at that verdict. That's improper under 441. You can read it. Secondarily, the issue of fault. Pick did not eliminate causation. It moved it around, but it just got rid of the proximate cause instruction itself. It's still alive and well, as you've seen in 105. And it's interesting because the Pickens committee itself on its notes and use talks about that. It says, hey, you may need to modify these instructions in cases like personal injury and things of that sort, because they're not going to work perfectly for you, which is exactly what we've done. In 38 years, I've been trying these cases for personal injury, medical malpractice, mostly medical malpractice for the last 30 years. We have used what I did in this case, every single one of them. This is the first time I've had a case where we haven't done that. And it's worked successfully. In fact, I was on a bench bar committee, and I suggested to the bench bar, who also has judges on it in the 18th Judicial District, I said, we need to do something about the pick instruction here. We got a problem with the med mal cases. So we all sat down with the committee, defense and plaintiff and the judges, and we came up with the language that we're using right now, because the pick says to do it. So we did it. So fault's not gone. Fault's important because it's contributed to, caused or contributed to. So any of the things that we've listed, the jury could have gone and said, hey, caused or contributed to, yeah, definitely his failure to recognize the fracture, so the shunt was malfunctioning on 3 separate films that he ordered and looked at, contributed to failing to make the diagnosis, which ultimately led to her death. So anyway, it's still there. You need to have it. It needs to be in an instruction. We have a right to put it in our contention instruction. It should be in a standard of care instruction because it is the law that needs to be applied. Thank you.
Other questions? Thank you. This matter will be taken under advisements. Thank you very much for your evidence. I will now call the case of State of Kansas versus Charles Hunter, 128056. Counsel, you may approach.
May it please the court, the state appears by Deputy Solicitor General Chris Elslager.
May it please the court, Joseph Dash appears on behalf of Charles Hunter.
Thank you. Mr. Elslager.
Just a little awkward for me to be on the other side. I'm not over there.
Yeah,
very
I'm
often.
not used to reserving 3 minutes for you, Mr. Elslager.
Yeah, yes, Your Honor. I did request 3 minutes of rebuttal. This case, the state contends that the Court of Appeals reached the wrong decision simply because it misinterpreted KSA 223430. The plain language of the statute says that a defendant can be committed for psychiatric care and treatment in lieu of confinement or imprisonment. It does not say in lieu of sentencing, but that seems to be how the Court of Appeals interpreted the statute. But the statute plainly contemplates a sentence of confinement or imprisonment first, and then commitment for care and treatment in lieu of that confinement or imprisonment. So the state contends that a correct reading of the statute leads to the conclusion that the district court may do exactly what it did in this case and sentence a defendant to imprisonment according to the sentencing guidelines for the crime of which he was convicted, and then following the statute, commit him to care and treatment in lieu of that sentence of confinement. I'm not quite sure how the Court of Appeals got to the position or got to the idea that the statute means in lieu of sentencing, but the state contends that it was error.
Could it have been subsection C that talks about the defendant's appeal rights? And I'm quoting, says in the same manner, so they have a right to an appeal in the same manner and with like effect as if a sentence to jail or to the custody of the Secretary of Corrections had been imposed.
Well, I think that's—
What do we do with that language, I guess?
Well, a couple things. First, reading the kind of the structure of all these statutes together, I feel like it contemplates the possibility of either commitment pre-sentencing or post-sentencing commitment in lieu of confinement. So I think the legislature was covering all the bases. Also, I think they wanted to make sure that no one was confused, or the state couldn't make the argument if a person was sentenced and then confined, that they couldn't then appeal that because they weren't actually in KDOC custody. They weren't serving a sentence. They were committed. So I think that protects. That's just a fail-safe measure by the state to protect the appellate rights of the defendant, to make sure that there's no misunderstanding about those. And like I said, there's provisions of the statutes. Like I say, you could read either way, and I don't think they're mutually exclusive of either committing a guy before sentencing, because another statute says that if the doctors determine that he can be, that no further help will come from having him committed, he can go back to the court. One of the options is that he can be sentenced. So I think there is the contemplation that it could happen before sentencing. But when you read that plain language in lieu of confinement or imprisonment, I think it also contemplates a post-sentencing commitment. And quite honestly, at the end of the day, this is the real head scratcher for me, because I inherited this case from one of my colleagues who retired. So I just came into this after the petition for review had been granted, and I'm just wondering what is the harm here? What does it matter one way or the other for the court? Because the statutes very clearly say that however long, if he gets committed, he cannot be committed for any longer than the maximum term that he would be sentenced to incarceration for. And any time that he's spent committed will count against any prison sentence. So there's no getting committed. It doesn't expand. It doesn't lengthen any of the time that the person is in custody.
It actually could in this case, because the sentence was for 130 months and the maximum term provided by law is 136 months, right?
Well, that is, yeah, that's one of the reasons why in my mind, I believe that the statute contemplates a sentence being imposed first.
What about that provision that I just read from, though, that it talks about that the court directs the defendant be detained in the hospital and no period of detention under this section? I mean, doesn't read as though the defendant would be serving him, because it talks about the detention not exceeding the maximum term of law. So that suggests to me there has been no sentence. In other words, why wouldn't it say no period of detention shall exceed the sentence imposed?
Well, I guess that's one way to read it. I read it as meaning you can't exceed the maximum term that has been imposed by the court according to the law.
That's not what it says. It says the maximum term provided by law.
And I guess
crime of conviction.
Okay, well, if you read the, you know, and I read
Doesn't
Mr. Obermeyer's brief, I came to the same conclusion is how do you know what? We read that as me, how would you even know what that was unless there's been a sentence imposed?
Because you look
You're
at the
saying just
statute.
the maximum possible.
That's what it says. And
Okay.
and again, I'm confused by this entire case because in part, I tend to agree with you that while it's important to get the law right, I'm not sure that there's any significant practical impact of which comes first, sentence or commitment. However, there might be a practical impact. And in this case, the state's arguing for a view that limits the term of confinement to 130 months. And it strikes me, and I'll ask defense counsel about this, the position defendant has taken may actually add 6 months to his period of confinement.
Well, I could see how that interpretation could be arrived at. The entire statutory framework is not, it's not entirely clear. That's why I felt like reading it all, that the statutes seem to contemplate either a pre or post-sentencing commitment. And I'm not sure that it really matters. And in this case, then you also have to wonder, I mean, this is what the defendant asked for. He asked to be committed. And he was at the time already committed. He had a prior sentence for crimes committed pre-KSG, an indeterminate sentence. And he had been serving, as far as I understand from the record, all that time at the Lorna State Security Hospital because of his mental issues. So then when this case came up, the battery on, I think it was battery on a corrections officer, he asked that it be served, that his sentence be served in commitment at the Lorna State Security Hospital. The state agreed. And this, I mean, he got what he wants or what he wanted. I'm honestly, in some ways, I'm not sure why we're here, other than perhaps
Well, the state filed a petition for review,
well,
right?
I mean, I think just to clarify I guess to clarify the law, to give the lower courts clear guidance on what they can and can't do. I think the way the law reads, it says in lieu of confinement or imprisonment, which implies that there has been a sentence of confinement or imprisonment. I think the Court of Appeals was wrong to say that the district court was wrong in light of that language. But at the end of the day, however this case comes out, I don't think it's going to have any substantive impact on the defendant, other than he may have a potential sentence hanging over his head, which I wonder why he asked for that. But as you've identified, it could extend his sentence if you were to read the statute that way. I don't think that's what he wants. But regardless, I think at the very least, this court could clarify the statutory procedure so the courts know. And my reading of it is the court has discretion to do this pre-sentence or post-sentence. And so there's no error here. And if there are no questions.
I have one more statutory question about a provision we haven't talked about yet. And I think it's 223431, which is some of the procedures about what happens when there's a commitment. And then there can be a hearing, and that's subsection C. Statute says that at that hearing, the defendant shall be, and then it has a list, sentenced,
Yes.
committed, granted probation, or assigned to community corrections. Doesn't that suggest that committal is a different thing from sentencing?
Well,
Different disposition. You don't get both. You don't get a sentence and a committing. You get one or the other.
well, this is what I was referencing kind of indirectly earlier when I was answering Justice Wall's question, is that it seems to be a catch-all that again, my reading of the statutory scheme is that there seems to be discretion with the district court to grant, to commit someone before sentencing or post-sentencing. And this just covers all the bases and says that at the hearing, then the court can consider all of these options based on the context of the case. That's the best I can answer that. I think that if you look at 223430, the plain language in lieu of confinement or imprisonment suggests that there has been a sentence of confinement or imprisonment, because before sentencing, there is no confinement or imprisonment in place. But clearly other statutory provisions that are related do seem to hint at the idea that, or suggest that someone could be committed before sentencing. So my take from that is that the legislature intended for the district court to have discretion to do it one way or the other, and that there's no error one way or the other. And I think that the facts of this case show that there's no error, because there's no to me, there's no substantive change for this particular defendant. He's going to remain at the Larned State Security Hospital, and he can't remain there any longer than the maximum length of his sentence. So if there are no further questions, I would simply ask that the court reverse the decision of the Court of Appeals and perhaps clarify the statute for the lower courts.
Any other questions, colleagues? Thank you, Mr. Elzler. Mr. Dash?
Thank you, Your Honor.
The state's position, I'm sorry, the state's position ignores the interpretive case law that's been laid out for this particular statute and all three of the particular statutes we're talking about. There is a Court of Appeals case, State versus Smith, that says that you have to have this done first, and sentencing is taken up afterward. Let me just put it this way in the first place. And Al, actually, I'm going to answer Justice Stiegel's question. What does this give Mr. Hunter? It gives him hope that he can get out. And he's been in prison for 48 years. 48 years since he was 16 years old. He has had no hope at all until now.
How does it, I mean, setting aside the psychological impact, articulate the hope that he may serve less time in confinement?
If you consider the provisions under which he was sentenced or should have been sentenced, you don't get to 3430 without going to 3429. You must have that evaluation first. And that evaluation must come before sentencing, period. That's what the interpretive case law says, and that's what Harkness took up when it echoed the holdings of Smith.
Right.
And Harkness was from this court. So
let's say the sentence is vacated. That's what you want, right?
That's exactly what, yes.
And he's serving his he's committed.
Yes.
And he can be committed up to the maximum of the maximum term of a sentence as provided by law. I think that's 136 months, right?
Right.
So, I mean, he could actually serve more time in commitment than he was actually sentenced, than the sentence you're claiming is illegal, right?
Yes.
And even if he didn't serve that time in commitment, he's not free to go when the commitment's over. He has to come back and be sentenced.
Or allowed to be free. Under 3431, the judge, the sentencing judge, has the ability to let him go. That's one of those options. They can determine that he needs to be sentenced, determine that he can be released. So that's his hope. It's not just, and here's the problem with all of this. The Court of Appeals decided it was a statutory interpretation question. And I would also suggest it's an ambiguity question because there's no, in the time and manner, how much time is he going to serve? Well, is he going to serve 130 months under the sentence, under the criminal sentence, or is he going to serve an indeterminate time until he gets better? Their time, that's ambiguous. Manner, is he going to serve his entire sentence in the Larned, or is he going to be allowed to get out and go back to prison? So the time and manner are both ambiguous. And ambiguous, we've been doing this since 1853. It's ambiguous can it be understood in more than one sense? So that sentence can be certainly understood in more than one sense. That's ambiguous as well as it didn't follow the statutory procedure. But the point being, and I looked back into this a little deeper to try to figure out why review was granted, because I think if you look at the statutes and look at the Court of Appeals decision, it's right, it's correct, it's proper. If you look at the three statutes under which he was committed and how that process works, it's independent of sentencing. In lieu of has always meant in place of or instead of. And that's exactly what the Court of Appeals said. And that's exactly what every definition that I looked up, I tried to find different places. I go back to Bouvier's law.
Would you agree with me that in this case, your client was sentenced first and then committed?
Yes and no. He was sentenced in one proceeding, and I have the proceeding. There was an anticipation he was going to be committed, and there was also this odd sentencing thing. but he was committed in the same period of time that he was
Right, but the
sentenced.
sentencing came first. That's the whole gravamen of your claim.
Yes and no. And I'm sorry, I didn't mean to interrupt you.
No, that's okay.
If you go to this court's decision in State versus DW, the case was that the judge changed her mind, and before the sentencing was over, fixed the sentence to clarify it. That was in DW Williams. I was here for that. This court said, court can change its sentence or change the character of its sentence while they're still sitting there, as long as it's not modifying entirely. So in DW would say, if you do this all in one sitting, then it's all one sentence. So that being said, I also want to hit up one other issue of preservation here, because the state in its brief did not bring up the definition of commit. It did not bring up this stuff. It did bring up three things. It brought up first that the parties agreed to this. Well, the parties can't agree to an illegal sentence, and the district court can't oblige them in giving one.
Trying to figure out what makes this, let's assume that this sentence is illegal. And I want to
Why is it?
understand what portion of it, because it seems to me there's two things. One might be the sentence as a whole is illegal because he was committed, and you can't sentence somebody after they're committed.
That would be my position. Yeah.
Right, but that's why the word after is key, like it's the timing matters. The alternative view might be there was a lawful sentence. In part, what makes it illegal is the destination. In other words, that Mr. Hunter was sent to the hospital, not to prison.
Right,
And-
because KDOC would have the only
And
authority
that, I
to do
mean,
that.
the outcome is very different here. In other words, this does seem like a be careful what you ask for scenario, because one reasonable view, it seems to me, is this sentence is illegal because the district court did not send Mr. Hunter to prison. And we're going to remand, and we're going to say, impose the correct sentence, and he's going to get moved from the hospital to the prison.
That's a
And that's a bad
possibility.
result from your client's perspective,
That's a
right?
possibility. He's been there and back several times. So I don't think he's going to worry about, first off, I don't think he's going to worry about 6 months when he's been in prison his entire adult life. He wants the hope of being able to get better. And that's what he's been trying to do.
Well, where is he? Is he at the?
He's in Larned. He's been in
Okay,
Larned for,
He's in the hospital.
yes,
He's not in the prison.
yes, that's correct.
You said he'd been in prison his whole life, but
Well, okay.
He's
he's
technically
been
correct. He's-
Confined his entire adult life.
his confinement is in the state hospital.
At this time it is. And if you read also the, which I won't say the Casper, because there's a attachment on the brief that shows that he's not in KDOC custody. KDOC has said, we don't have him. They don't. Because, and to answer your other question, because we did the 3429 examination, it leads to two conclusions. Either you can take the 3429 recommendations and commit him. That's job one. Or you can take those 3429 recommendations and forget it. We're not going to commit him. We're going to just sentence him to prison. And so I think under the auspices of what did they do? Well, if you read the whole sentencing transcript, I'm sure you have, the idea was to place him in the hospital and where he was. And the good intentions, we all know where that takes us sometimes. But the long and the short of it is he was committed in this hearing. He was also sentenced. He can't do both, because we've started the ball rolling with the 3429 examination and recommendations. So the next logical result would be either to commit or sentence. They're not the same thing. And I can't believe we're not even arguing that. I can't believe we'd be even thinking about arguing that, but there are a few unpublished cases that I did not brief, and I will just point them out briefly. There is a case called, and I did point these out to my colleague earlier in the week. There's a State versus Goraki, which is a 1994 case. All of these interpretive cases seem to be before sentencing guidelines took effect. But that's a 1994 case. And there's an eloquent discussion about this that at the very end of this decision, and I'll give you the 1994 Can-Am Unpub Lexus 382, number 7516. A court which chooses to exercise the conditional grant of authority conferred by 22-3430 to commit the defendant for psychiatric care and treatment does so in lieu of sentencing. A commitment under 22-3430 is not a sentence and should not be considered a condition of a sentence imposed. By deferring sentencing in these cases, the legislature expressed its intent that the sentencing court take into consideration not only the facts and circumstances existing at the time of the commitment, but also those existing upon completion of treatment. So this is to give the sentencing court, if it ever gets back to sentencing, another option, another thought, another consideration to take into account before sentencing. But
Can I ask you
yes.
what we, in terms of a remedy, maybe going back to Justice Stiegel's question, how it's framed and characterized may impact what remedies are on the table? Because if your argument is that this simply fails to conform to the statutory scheme because no sentence should ever have been imposed, a sentence under the Kansas Sentencing Guidelines Act, maybe you're suggesting this court could just vacate sentence. But if there's ambiguity, if your claim is based on ambiguity under the illegal sentence statute, it might require remand. What do you think
that could
the
have been,
paths available, and which one are you suggesting for us?
that could have been the Court of Appeals panel's thinking in just vacating the Kansas Sentencing Guidelines sentence. They just simply vacated the sentence and said the commitment is good to go. And when, if at all, he's determined to be better, then we will go to the sentencing.
Yeah, they basically reasoned that you can't have both. So
Right.
we're going to give the commitment priority.
Yes, they did. And I
But
think
why isn't the correct result to say you can't have both? We're going to give the sentence priority.
because I think
That's the correct result.
public policy is to
Well,
we
we're
don't.
not here for public policy.
Okay.
We're here under an illegal sentence motion.
Yes,
And
but
this, if you can't have both,
there's got to be a reason for putting people into psychiatric commitment rather than prison. And that's for the betterment of the person and the system, because the system.
but your whole argument is that if you get sentenced, you shouldn't get committed. And your
No,
client
well-
was sentenced.
He wasn't. You have to look at the sentencing transcript to understand that their idea was to commit him. And apparently it was for a period of 10 years, which can't be done under the commitment statutes. But I just think that if you take into consideration the entire thought process that the court went through and the parties went through, just to see, here's how we affect getting him back into the care that he needs. This is how we're going to do it. I have no idea why they sentenced him, because that wasn't the correct thing to do. That was improper under the statutes and under the determination of what in lieu of has meant since time began. Or let's say since 1853, when the Bouvier said it was in place of or instead of. I think that the Court of Appeals got it right. And I think that this court should either return this as improvidently granted, or say that we agree with just initially make an opinion similar to theirs. But I do think there still is an ambiguity issue. And it, just like Justice Wall suggested, that might suggest a resentencing. But I think there's still under the framework of the 3429, 3430, and 3431, because we started there before sentencing. And when you start one process, you have to finish it. And that's all I have. If there's no further questions, I'm going to.
Any further questions, colleagues? Thank you, Mr. Dev.
Thank you.
Mr. Elslager, you reserve 3 minutes.
Thank you, Your Honor. I think that Justice Stiegel has nailed why the Court of Appeals was wrong. Because the as he pointed out, the sentence was imposed. And so it hadn't occurred to me, maybe because I came into this case late and wasn't involved in all the litigation before, that as what he said is that really, if you were to take my opposing counsel's, the defendant's argument to its logical conclusion, the illegal portion of the sentence, if it is an illegal sentence, is where it's being served rather than.
In other words, the state's view of the statute, as it was briefed at least, might be wrong, or if we disagreed with it. But the impact of that would be that what was illegal here was the commitment. In other words, the commitment should never have happened.
I think if you follow my opposing counsel's argument and you go with the Court of Appeals, I think that would be the case. That's not. I don't think that's what the legislature wanted. That's not actually what the state wanted in this case. To answer my question, why we're here, what the state wants is simply to maintain the status quo. I mean, that's all along, but the Court of Appeals gave us what we think is a flawed decision. It needs to be corrected by this court, but I think the procedure that the district court followed here was correct.
Well, let me just ask it this way. I understand this isn't your position, but if this court were to disagree with your position and agree with the Court of Appeals, that you just simply cannot have a simultaneous sentence and commitment. That doesn't exist in our law. If that's true, which should take priority in this case, the sentence or the commitment?
Well, the sentence came first. And there's nothing in the statute that says that even when the district court receives the report from the mental health professionals, that it has to commit him. That's to the discretion of the district court. And arguably the district court exercises discretion here by imposing sentence, a lawful sentence. There's nothing unlawful about if he said you're going to serve 130 months incarceration of the Department of Corrections, there's nothing to be appealed there. That would be a completely lawful sentence and we wouldn't be here. It was the next step following the plain language of 223430 that the judge shall have the power to commit a defendant in lieu of confinement or imprisonment, which indicates to me that our position is that the district court follow the correct procedure. And I guess my questioning all along was why did this defendant file this motion in the first place? Because what is he going to get out of it? As you pointed out, he's facing a lot of risk and no benefit. The state's position is that it was correct all along, and we're just here to maintain the status quo. And so, unfortunately, the Court of Appeals decision upsets the status quo, and I'm asking this court to return it.
Any other questions? Thank you, Mr. Ellsworth. This matter will be taken under advisement, and that concludes this week's docket, and court is adjourned.
All right.